Hi everyone and welcome to SEO Explains. My name is Gavai and today we're going to discuss a case that may influence the composition of High Court benches for many years to come. This was one of the final Constitution Bench cases of Chief Justice B.R. Gavai's tenure. The judgment was pronounced on 19th November and answers several questions on the determination of seniority within the District Judiciary. It primarily looks at whether civil judges require reservations in promotion to the post of Principal District Judge. In this video, we break down central arguments of the case. The matter was heard under the All India Judges Association versus Union of India case, which was instituted in the Supreme Court all the way back in 1989. It has been kept open by the court under what is called a continuing mandamus to hear all matters related to the architecture of judicial services, especially with regard to recruitment and promotion. This case was referred to the Constitution Bench back in September by Division Bench of CJI Gavai and Justice K.V. Chandran. They heard submissions from amicus Siddharth Bhatnagar, who pointed out that most civil judges retire without ever reaching the rank of Principal District Judge, let alone being considered for elevation to the High Courts. After receiving divergent responses from states and high courts, the bench warned that this stagnation is deterring bright young lawyers from entering the service. It referred the case to the larger bench, seeking a more meaningful and long-lasting solution. Notably, this reference is one of several recent structural interventions. In May, the court brought back the 3-year practice requirement for entry-level civil judges of the junior division. In October, it held that judicial officers with 7 years of practice are eligible for appointment as district judges under the bar stream. At the heart of this case is a deeply consequential question. How should seniority be determined within the district judge cadre? Across promotees, LDCE, that is Limited Departmental Competitive Examination entrance, and direct recruits from the bar. The stakes are high because principal district judges are the most senior among the district judiciary, and high court judges are often drawn from this very pool. Civil judges are demanding reservation and promotion so that they don't lose out to those who've entered the judiciary through direct recruitment. Mode of entry matters because of the difference in age at the time of entry and how that affects promotion later on. It takes several long years of service for civil judges to reach the rank of district judge, leaving them very little time to have a shot at higher posts. Meanwhile, direct recruits from the bar arrive at a much younger age. In All India Judges Association 2002, the court suggested a ratio of 75:25 between promotees and direct recruits to ensure a balance at the point of entry. However, this does not alter the time that an officer has left to serve before retirement, and it is often that duration which determines who is considered for elevation. As one counsel said during the hearings, the stream of entry effectively serves as a birthmark upon applicants. Another issue placed before the bench is that the 2002 ratio assumes that recruitment will take place in a regular manner. In practice, however, recruitment cycles are often delayed, irregular, and with long periods of time between the examination and the official promotion. This leads to a situation that the petitioners call bunching, where several officers enter service all at once. It has several disadvantages. For instance, with calculation of seniority, if officers who enter from the LDCE route are bunched in with in-service promotees, it leads to a situation where they would have been better off not writing the examination and simply waiting for promotion instead. It's important to note that these concerns don't travel evenly across the country. Some high courts have requested the bench to avoid further standardization, highlighting that recruitment patterns, vacancy rhythms, and promotion cultures vary considerably across the state. They stress that Article 235 allows high courts to maintain discretion over management of their own judicial services. My colleague Namrata Banerjee has been covering the hearings, and reading her reports, it is evident that the court is no longer treating these cases as isolated service disputes. Rather, the conversation keeps circling back to the foundations. What should influence progression? Trial court experience or the number of years one has left before retirement? Should quotas shape the pipeline? And ultimately, what model of progression will produce the most capable benches in the higher judiciary? The answers that the court lands on could influence who becomes a judge and how their careers proceed for several years to come. As always, Supreme Court Observer will be covering the judgment, so look out for our judgment summary and matrix. Thank you for watching and follow SEO for more.